Hello everyone. In this presentation, the focus would be on exceptions to the doctrine of mens rea. We have seen that the general rule of criminal liability is that a person will not be liable for a guilty act unless he does it with a guilty mind. This rule is subject to certain exceptions, and such offences for which mens rea is not an essential element are called offences of strict liability. Before going to the offences of strict liability, we have to understand that this concept of mens rea is an English concept and it is applicable to all common law offences. Now, what are common law offences? So far as the English law is concerned, there is a classification between common law offences and statutory offences. Common law offences are offences under common law, that is, they are developed entirely by the law courts and have no specific basis in statutes. When they are codified and brought out in the form of statutes or acts, they become statutory offences. Now, so far as India is concerned, we do not have the distinction between common law offences and statutory offences. So, all the offences under the Indian Penal Code are statutory offences only. Now, coming to the doctrine of mens rea, we have seen that the rule is subject to certain exceptions, and such offences for which mens rea is not an essential element, they are called offences of strict liability. Now, offences of strict liability can be classified into three categories. One, acts that are not criminal in the real sense but are quasi-criminal in nature and are prohibited in public interest under a penalty. This category includes social and economic offences like offences relating to food and drugs, revenue offences, traffic offences, etc. Cases of public nuisance, libel, contempt of court are the second category of strict liability offences. The third category consists of cases where, though the proceedings are criminal in nature, it is only a mode of enforcing a civil right. For example, the violations of municipal laws and regulations fall under this category. The exclusion of mens rea from these three categories of offences is justified because regulations are enacted by the legislature to preserve and protect social and economic interest of the community, and therefore they have to be strictly enforced. Punishment provided in such cases is generally a nominal fine, and the object of these regulations is not to punish but to pressurize people to discharge their duties properly in the interest of public health, safety, and convenience of the community. Under certain circumstances, the state prohibits by statutes the doing of certain acts, irrespective of whether mens rea is required or not. Where the offences have been defined precisely in a statute, should the principle of mens rea be excluded is a question. Should it be construed that Parliament or legislature created an absolute offence without mens rea or a conditional offence with mens rea underlying it? In R versus Prince, a literal interpretation of a penal statute, totally rejecting the idea of mens rea was taken by a majority of 15:1 by English Court for Crown cases. In this case, Henry Prince was tried for abducting a girl under the age of 16, believing that she was 18, going by her appearance and utterances. By Section 55 of the Offences Against Person Act 1861, taking unlawfully any unmarried girl under the age of 16 years out of the possession and against the will of her father or mother amounted to abduction. It was no defense to plead that the accused bona fide believed and had reasonable grounds to believe that the girl was over 16. The court held that the intention of the legislature appeared to have been to punish abduction unless the girl is in fact of such age as to make her consent an excuse, irrespective of whether he knew her to be too young to give an effectual consent, and they fixed that age at 16 years. Thus, a man who has connection with a child relying on her consent does it at his peril if she is below the statutory age, that is 16 years. Now, a contrary conclusion, substantially giving effect to the doctrine of mens rea, was arrived at by the judges in R versus Tolson in 1889. Here, Mrs. Tolson was charged of bigamy under Section 57 of Offences Against Person Act, according to which marrying any other person during the lifetime of a spouse was an offence. However, if at the time of such marriage the spouse has been continuously absent from such person for a preceding 7 years and his or her whereabouts are not known, that is, he or she is not known to be living within that time, or if the person at the time of second marriage had been divorced from the bond of first marriage, Section 57 will not be applicable according to the provisos to Section 57. Here, Anne married Mr. Tolson in 1880. In November 1881, Mr. Tolson deserted her, and as a result of her inquiries, she was made to believe that he was lost in a vessel that went down with all hands on board. Hence, in January 1887, Mrs. Tolson, believing herself to be a widow, married Y. After informing Y about her first marriage and about her husband, Mr. Tolson returned in December 1887 and brought an action against Mrs. Tolson for bigamy. The court held that Mrs. Tolson cannot be convicted for bigamy because the case fell under the plea of mistake of fact, and the conduct of the woman was not immoral but natural and legitimate. She acted bona fide under the honest belief that her husband was dead. Now, contrasting this decision in R versus Wheat and Stocks in 1921, where the accused was charged of the offence of bigamy and raised the plea of divorce from the first marriage, the court held that a belief in good faith and on reasonable grounds that the accused has been divorced when in fact he was not affords no defence to a charge of bigamy. In the case of first exception, belief afforded a ground for defence, and as such, reasonable bona fide belief had to be recognized as a defence. But in the case of second exception, actual divorce alone afforded a ground for defence. Hence, it was held that a bona fide belief on reasonable grounds that the accused had been divorced when in fact he was not affords no defence in law to the charge of bigamy, although it may afford good reason for infliction of nominal punishment. Now, clear enunciation of the principles relating to applicability of the doctrine of mens rea under statutory offences is found in the decision of Privy Council in an appeal from the High Court of Singapore in Lim Chin Ek versus R. The appellant Lim Chin was born in China. Subsequently, he moved to Singapore and lived there up to 1954. He moved out of Singapore under suspicious circumstances and started living in Malaya. His family was in Singapore and he visited his family daily and returned to Malaya in night. In May 1959, an order was made against him prohibiting his entrance into Singapore under the Singapore Immigration Ordinance. Section 9 of the ordinance empowered the minister to issue such orders against any person or class of persons in the interest of public security. Violation of orders issued under Section 9 was made punishable under Section 6, 2 and 3 of the ordinance. Section 9(3) of the ordinance provided for publication of an order directed to a class of persons, but not for the publication of an order directed to an individual. Lim Chin was apprehended and convicted under Section 6(2) and 6(3) of the ordinance. In appeal, Lim Chin pleaded that he could not comply with the order because he did not know of it and no practical means of his ascertaining that he had become a prohibited person was provided by the ordinance. His plea was accepted and the appeal was allowed and his conviction quashed. Therefore, under the English law, there is a presumption that mens rea, an evil intention or knowledge of wrongful nature of an act, is an essential element in every common law offence. This presumption can be displaced either by words of the statute creating the offence or by the subject matter with which it deals. If a statute contains an absolute prohibition against the doing of some act, as a general rule, mens rea is not an element of the offence. But where a statute imposes a duty to do something on the happening of certain event, unless the man knows that the event occurred, he cannot carry out the duty imposed. Now, so far as India is concerned, the principle of strict liability is recognized in the case of public welfare offences for social purpose or public policy. The reasons for recognizing the principles of strict liability are: 1. Such offences involve only monetary penalty. It would be difficult to prove mens rea in such offences, and in such offences, effect is required to be given to the social purpose behind the act. As such acts are not crimes per se, that is, not criminal in nature but are acts prohibited due to social expediency, they do not require mens rea. The law relating to mens rea was reviewed by the Supreme Court of India in State of Maharashtra versus Mayor Hans George. Here, the accused was prosecuted for bringing into India prohibited quantity of gold in violation of the provisions under the Foreign Exchange Regulation Act 1947. Section 8(1) of the Act lays down an absolute embargo on persons bringing in gold without special or general permission of the Reserve Bank of India. One can bring or send to India any gold only after satisfying the conditions, if any, prescribed by the Reserve Bank of India. The provision is absolute, as Section 24(1) says that when a person is prosecuted for contravening any provision of the Act, the burden of proof is upon him to show that he had the requisite permission. Central government, in exercise of the powers under Section 8 of the Foreign Exchange Regulation Act, issued a notification in the Official Gazette on 25th August 1948 by which it directed that except with the general or special permission of the Reserve Bank of India, no person can bring into or take out of India any gold. The Reserve Bank of India, by a notification of the same date, that is 25th August 1948, granted general permission for transit of gold through India from a place outside India to a place outside India when not removed from the aircraft except for the purpose of transshipment. However, on 8th November 1962, the Reserve Bank of India modified the earlier notification and added a condition for exemption which stated that the gold must be declared in the manifest of the aircraft as transshipment cargo, and this was published on 24th November 1962. Mr. George left Zurich to Manila by a Swiss aircraft on 27th November 1962, which landed in Bombay on 28th November 1962. On a search of the person of the respondent, 34 kgs of gold bars were found, which was not mentioned in the manifest as transshipment cargo. He was prosecuted for importing gold into India in contravention of Section 8(1) of the Foreign Exchange Regulation Act, read with notification issued thereunder, and convicted under Section 23(1)(a) of the Act by the trial court. On appeal, the Bombay High Court set aside the conviction on the ground that the respondent did not know that during the crucial period, a condition has been imposed for bringing gold as transshipment cargo, as the notification was published only a couple of days before his boarding the flight. On appeal by the state, the Supreme Court set aside the order of acquittal of the Bombay High Court and restored the order of conviction of the trial court. The court held that the respondent could be convicted under Section 23(1)(a) of the Foreign Exchange Regulation Act 1947 for violating the order made by the Reserve Bank of India in this regard. On the language of Section 8(1) read with Section 24(1) of the Act, there is no scope for invoking the rule that in addition to mere act of voluntarily bringing gold into India, any mental condition is prescribed as necessary to constitute an offence of contravention referred to in Section 23(1)(a). The court further held that the very purpose of the Act is to safeguard and conserve foreign exchange, which is essential to the economic health of a developing country, and its effectiveness would be frustrated if a condition were to be read into Section 8(1) or Section 23(1)(a) of the Act, qualifying the plain words of the enactment that the accused should be proved to have knowledge that he was contravening the law before he could be held liable for the contravention of the provision. Thus, under the penal code or under any penal statute in India, the general doctrine of mens rea is applicable whenever the definition of the offence is defective or incomplete, unless there is an express exclusion by the statute itself, where the statutes are prohibitory in nature, wherein the acts prohibited are not really criminal but are made penal in public interest, unless qualifying words like knowingly, willfully, etc. are used. The prosecution has to prove the prohibited act, and the accused, in order to earn an acquittal, has to bring his case within the statutory defense. Where the qualifying words are used, the prosecution has to prove all those elements either by direct evidence or by circumstantial evidence. Thank you.